Welcome back to the Weekly Friedman, your source for the most essential information in the default industry. Today, we're discussing a federal district court case in New York, Baker v. Rokosz, which challenged a common understanding in the industry that loans made to business entities are exempt from the Federal Truth in Lending Act. Joining us today is Steve Vargas, Senior Appellate Counsel at Friedman Vartolo, an attorney accustomed to navigating complex New York foreclosure issues, and a frequent guest on the Weekly Friedman. Steve, how's it going?
Hey, good afternoon, everybody. Nice to be back.
Glad to have you back. So, Steve, let's unpack the complexities of this decision. So, look, while the headline was that there are instances where TILA would apply in transactions with a corporate borrower, it wasn't solely limited to that act, right? You want to walk us through where the judge extended the ruling to?
Of course. The Truth in Lending Act applies to typically two types of consumers: party to whom the credit was offered or extended, and the primary purpose of the loan has to be for personal purposes. And the holding in this case turned on the district judge's interpretation of the definition of the party to whom the credit was extended, as well as the purpose of the loan, whether it's a personal or business purpose loan. And contrary to the conventional wisdom, the judge found in this instance that a loan that was actually signed by a corporate entity with a natural person signing on behalf of the entity qualified for coverage under the Truth in Lending Act, but as well as the Home Ownership and Equity Protection Act and Banking Law 6L, which is a New York state law.
All right, but we're saying here the rationale behind this decision, like this didn't just extend these protections to all businesses, right? This is because the lender in question required a natural person to form the business entity to secure the loan. Is that correct?
Correct. Each of the three statutes I mentioned, the two federal laws and the one state-specific law, apply as consumer protections. Consumers, according to case law and even the statutory text in these instances, are defined as natural persons, and in the instance of HEPA, a natural person whose primary residence is the mortgaged premises. So yes, it was a narrow holding limited to a very specific set of facts here, but the statutes across the board generally apply to natural persons, and then there's exceptions that were drawn by the judge in this case.
Do you believe this is sound reasoning? Like, presumably, part of the reason the lender said we won't loan to a natural person, we'll only loan to a corporate entity, is because the laws governing that type of a borrower would be different. So now to say the lender said we would not lend to a natural person, we'll only lend to a corporate entity, to then say, well, all the laws for natural persons now apply to this entity or this relationship or this transaction, it feels counterintuitive. Like, how would the lender know which laws govern a transaction?
That was the point of contention in litigation here. As far as the facts were concerned, a natural person borrower was seeking to finance work or repairs on a property, primary residence. The lender conditioned the loan approval or loan funding on the natural person creating a corporate entity and signing the loan documents through the corporate entity. As you said, there's no carve out in any of the three laws, TILA, HEPA, or banking law, that contemplates a scenario like this. They typically define the borrower as a natural person, a consumer as a natural person. Talking about primary residence, only a natural person can have a residence. A corporate entity wouldn't have a residence as defined by the statutory text. But the judge said here, because a natural person initially applied for the credit in an individual capacity rather than as an agent for a corporate entity, and that the lending was conditioned solely on creating the corporate entity, that this specific fact pattern fit into the statutory protections that were set by Congress and the New York State Legislature with respect to these three statutes. As far as the soundness of the reasoning that you had questioned earlier, I think there are some questions as to it as well. it's possible that this case is the first within the trial courts within the U.S. Court of Appeals for the Second Circuit, first time where this sort of ruling has come out. This is U.S. District Judge Caillou Matsumoto, who's a very well-respected judge, issues very well-reasoned opinions. This was a lengthy opinion. It is currently the subject of a motion for reconsideration in the federal district court, potentially an appeal down the road as well. So the fact it's the only one of its kind, and these laws have been in existence for a number of years, and with the frequency of litigation regarding TILA, HEPA, and banking law, you'd think there'd be a decision that would have been similar to come out by now if the reasoning were sound. Right now, it's district court law. It's not binding appellate precedent. It's persuasive to a degree, but like you said, it is an outlier. It is very fact-specific. The judge in the decision noted that the vast majority of decisions that have come out and the conventional wisdom is that these laws only apply to a natural person, and then with a corporate entity whose name appears on the loan documents would not be protected by consumer protection statutes. The judge said, notwithstanding that, with these facts, I'm going to apply the law in a different manner, and in doing so, ruled in favor of Barker in all three instances, finding there were violations of TILA, HEPA, and banking law because Barker admittedly did not comply with any of those laws, believing they were inapplicable. But to your point, the judge, I think, found that the plaintiff was looking for, the defendant was looking to circumvent the consumer protection laws by forcing the natural person to create the corporate entity to avoid having to comply with these laws. And I think that was a big factor in what the judge ultimately decided to do with the case.
What will this do to the lending industry? So I imagine it's not incredibly common for a lender to require a natural person to create a corporate entity if they want to borrow money. So will this make waves? Will this be noteworthy? Will it have a drastic impact on the industry?
I don't think it would be that impactful. I think it is an outlier. I think there are unique circumstances here. It's something to be aware of, is what that would be my warning to the industry. It's certainly a risk to litigate this issue in a federal court. This is the Brooklyn Eastern District Court, which among all the district courts in New York is arguably the most consumer friendly, not only in district court litigation, but in the bankruptcy courts. So the judges in that court that primarily deal with cases in the five boroughs, most of the five boroughs, they are protective of consumers to a greater degree than maybe the Eastern District in Islip or the other district courts in New York. So you are dealing with a situation where you have a venue that's consumer friendly. So I think in that venue, you should look at this, especially with a district judge as well respected as Judge Matsumoto. It's something to be aware of there. With that said, some lenders, their business model is lending to corporate entities, and I think in those instances, they may want to consider what sort of lending practices they want to have in connection with the application solicitation processes, and whether they want to try to proactively comply with these laws, and then in litigation down the line, maybe take the position they didn't apply, but in an abundance of caution, we gave some consumer protection notices anyway.
Correct. All right, so to recap, this decision extended TILA, HEPA, and other state law protections to natural persons, where the natural persons was effectively the true borrower and not the corporate entity. Lenders need to tread carefully. Thanks for joining Steve Vargas and I on the Weekly Friedman, your source for the most essential information in the default industry. Join the conversation. If you have any questions or comments, please leave a comment below. I look forward to seeing you next time, and thanks for tuning in.